Hello, I am Sumesh Ghatkamble from MBA Department, KLS Gopte Institute of Technology, Udyambag, Belgavi. This video is about authorities' rights and liabilities of partners. So first, let us all understand what is authorities of partners. Authorities of partners, subject to the provisions of Section 22, the act of a partner which is done to carry on in the usual way. Business of the kind carried on by the firm binds the firm. The authority of a partner to bind the firm conferred by this section is called implied authority. There are three types of authorities: express authority, implied authority, apparent authority. Express authority, granted by words or contract that, reasonably interpreted, cause the agent to believe the principal desires to act. In ambiguity about the principal's intent, the courts look at the principal's objective manifestation, not subjective intent. Implied authority. Unless otherwise agreed, authority to conduct a transaction includes authority to do acts that are reasonably necessary to accomplish it. Apparent authority. A principal can be liable for the acts of an agent who is not, in fact, acting with authority if the principal's conduct causes a third party reasonably to believe that the agent is authorized. An agent with actual authority may perform an act beyond the scope of that authority. If the action appears to the third party to be within the scope of the authority, the principal will be bound. Rights of partners. What is rights of partners? Partners generally describes in the deed the proportion in which share of the firm. Partners can also make some payments and incur liabilities through their business. Unless otherwise agreed by the partners, every partner has following rights. The first one is right to take part in the conduct of business. Each partner can participate in the conduct and management of the business of the firm. Right to be consulted. Each partner has the right to express his opinion and be heard in all matters affecting the business of the firm. All decisions will, however, be made by majority with the exception of certain matters like change in the nature of business and reconstitution of the firm. Right to have access to books. Each partner has the right to inspect and copy any of the books of the firm, but a minor admitted to the benefits of the firm can inspect and copy only the books of others. He cannot claim access to other books of the firm. Right to share profits equally. Each partner will share the profits of the business of the firm equally. Right to be indemnified. If partner has to be indemnified by the firm in respect of all expenses and liabilities incurred by him in the ordinary and proper conduct of business. Right to claim interest on capital. Normally, no interest is allowed on the partnership agreement provides for the payment of interest on capital. It shall be payable only out of the profits. Right to interest on advances. If partner has advanced some amount of loan to the firm, he will be entitled to interest at a rate agreed upon and where no rate is decided. At 6% per annum, interest on loan will be payable even if there are losses. Right to use partnership property. Every partner is, as a rule, a joint owner of the partnership property and is entitled to have held and applied exclusively for the purpose of the business. Right in emergency. A partner has the right in an emergency to do all such acts as are reasonably necessary for protecting the firm from loss. Right to stop the admission of new partner. Every partner is entitled to prevent the introduction of a new partner into the firm. As per rules, no new partner can be admitted without the consent of all the partners. Right to do competing business. Every outgoing partner has a right to carry on a complete competing business, but he cannot use the firm's name, solicit the firm's customers, or represent the firm. Liabilities of partners. In liabilities of partners, every partner is jointly and severally liable for all acts of the firm done while he is a partner. Because of this liability, the creditor of the firm can sue all the partners jointly or individually. Following are the liabilities of a partner to third parties. The first one is liability of a partner for acts of the firm. Every partner is jointly and severally liable for all acts of the firm done while he is a partner. Because of this liability, the creditor of the firm can sue all the partners jointly or individually. Liabilities of the firm from wrongful act of partners. If any loss or injury is caused to any third party, or any penalty is imposed because of wrongful act or omission of a partner, the firm is liable to the same extent as the partner. Liability of the firm for misutilization by partners. Where a partner acting within his apparent authority receives money or property from a third party and misutilizes it, or a firm receives money or property from a third party in the course of its business and any of the partners misutilizes such money or property, then the firm is liable to make good the loss. Liability of an incoming partner. An incoming partner is liable for the debts and acts of the firm from the date of his admission into the firm. However, the incoming partner may agree to the liable for debts prior to his admission. And the last liability for a partner to third party is liability of a retiring partner. A retiring partner is liable to the acts of the firm done before his retirement, but a retiring partner may be liable for the debts incurred before his retirement if an agreement is reached between the third parties and the remaining partners of the firm, discharging the retiring partners from all liabilities. Thank you.